Lawline with your host, the distinguished New York lawyer, author, and lecturer, Alan Schnurman. Each week, Lawline will bring to you the most knowledgeable experts in the field of law today. And now we introduce today's guest and our host, Alan Schnurman.
Welcome to Lawline. Today we'll take an in-depth look into the medical, ethical, and legal implications of medical malpractice suits. Joining us in this discussion, we have Richard Shandell, past president of the New York State Trial Lawyers Association and chairman of the Medical Malpractice Committee. Dick is a member of the firm of Glazer, Shandell, and Blitz. Also joining us is Dr. Earl Greenwald. Dr. Greenwald is director of the Department of Obstetrics and Gynecology at Staten Island Hospital and medical director of the Medical Resource Group. Welcome, gentlemen. Dick, what is medical malpractice?
Medical malpractice is defined in the law as a breach by a physician of one of the four obligations that a physician owes a patient. The duty to use reasonable care and skill, the duty to use approved methods in general use in the community, the duty to keep up with the times and employ the most modern practices, and the duty to use his own best judgment in the treatment of a patient. The failure to conform to those duties that injures a patient is medical malpractice.
And doctor, what is the Medical Resource Group which you're chairman of?
The Medical Resource Group is an organization which specializes in explaining technical medical information to others. Our primary pursuit right now is in working with lawyers in determining the merit or the non-merit of a case, and then working with them to further understand the medicine involved in the case.
Well, how do you feel about legal medical malpractice suits? Here you're a physician. Dick brings some of the largest suits here in the state. What's your opinion of that?
Well, I have nothing to argue with Dick about in that respect. I see a lot of frivolous suits that are brought, but I think that there is a lot of utility and a lot of important input into the medical system and quality of care that finds its way into medicine, unfortunately, by this route.
Dick, how do you answer those physicians that say the lawyers are driving up malpractice rates, they're incurring additional costs for the patients, that the awards, which sometimes run into hundreds of thousands of dollars and in certain circumstances even over $1 million, should be stopped and limited? How do you answer them?
Well, nobody gets a $100,000 or $1 million award who hasn't been tragically injured. Is there to be immunity on the part of physicians from legal responsibility for wrongdoing? Why are doctors to be immunized from being required to compensate some patient that they've injured as a result of negligence? As far as their premiums are concerned for their insurance, everybody pays insurance premiums to protect themselves against liability. I would say that as a percentage of the average doctor's income, their medical malpractice insurance premiums rates are lower than the percentage of his income that a New York City taxi driver has to pay for his liability insurance. So it's not a great imposition. As far as driving up the cost of medical care is concerned, I think that what medical malpractice suits do is cause physicians and hospitals to take a second look at their practices and to improve their practices. If to some extent that sometimes drives up the cost of medical care, that's to the good. I know that there are many practices at hospitals and by physicians that have improved because doctors and hospitals are afraid of medical malpractice suits. Many improvements that have been put in that doctors and hospitals used to say, we can't afford. We have a limited budget. And now they've put them in to the protection of the patient because of the impetus of medical malpractice suits.
Doctor, you heard what Dick had to say. Do you agree with it? Do you disagree with it? Has it improved the medical profession?
I really hate to say it, but I think that it in fact does. I've observed the same thing in my work through Medical Resource Group. I wish that I could say that physicians and hospitals have developed effective peer review and quality assurance routes. They haven't. They are not functioning well yet, and I think that the lawsuit and the fear of lawsuit and the ability to look back and see the terrible destructive nature on the medical community is one of those deterrents to negligence and one of those things that convinces institutions and physicians of the necessity to be current and to buy that equipment and construct those facilities which are needed.
That raises a question which I have. We have a hospital here. You're a director of a major hospital department. What happens when you actually see a doctor doing medical negligence, medical malpractice, and you see it done once? Do you see it done twice? What is your responsibility? What do you do? What do you recommend the medical profession do as a whole when that occurs?
When a physician is negligent, I think that everybody in the professional life at some time or another will be careless or negligent in providing the professional services. It depends on how severe that error or that bad care is. When bad care is delivered, that is generally reflected to me by some individual. It can be by the doctor himself, it can be by a resident, by a nurse, by any other individual observing it, by a patient. And I address that issue directly with the doctor. If it's repetitive, then we get into the area of taking punitive action. And punitive action can be in the range of depriving that physician of the right to perform that particular service or that procedure, or it can be in the form of terminating his eligibility or his service in the department.
Yes, but then this doctor, I assume either he leaves your hospital or he's asked to leave, then he goes to another hospital. He may do the same exact thing in another hospital. What do you think of that, Dick?
I think that's very common. Lawyers can be disbarred, priests can be unfrocked, army officers can be drummed out of the Corps. The doctors don't even have a name for it. It is the rarest thing in the world for a physician to lose the right to practice medicine because of some conduct or something he's done or something he's been caught at or something that his peers know he's doing repetitively to the injury of a patient. It just doesn't happen. In the last 8 years since the last malpractice legislation that passed our state legislature, which provided for a system for reporting doctors and a new system of investigation, doctors have reported approximately 13 doctors to the health department. Hospitals have reported none, and the insurance companies who were supposed to report the repeat malpractitioners have reported none.
I think Dr. Ringwald wants to respond to that.
Well, I don't want to totally disagree with you, but I think that there's an increasing awareness by the medical community of their responsibility to participate in the peer review process. Certainly, there are many instances in which physicians have lost their license and have been required, if at all possible, to retrieve or recover those licenses by fulfilling certain educational objectives.
I know of no physician who's lost his license because of something he did to a patient that was malpractice or gross malpractice. I know one or two who lost their licenses for sexually abusing a patient and one or two for criminal activities in another area, but actually a physician loses license because he's repeatedly practicing bad medicine? I know of no such instance in New York State.
Well, I think that physicians who are put in the position of defending themselves to state boards are also effectively represented by lawyers who throw up roadblocks to, I think, very credible attempts, and maybe initial and embryonic attempts, to approach the process of removing a license from an incompetent practitioner. In addition, the physician that malpractices and loses his privileges at one institution should have difficulty in gaining privileges at another. The institution, the credentials committee, and the departmental director or chairman who admits that physician into that institution has an obligation to the medical community and to the co-practitioners to thoroughly investigate that individual and to call those people with whom he's worked in the immediate past and confirm his competence. And I certainly would not admit to my department or to my institution the physician whom I hadn't checked out and the physician whom I had checked out and found demonstrated clear incompetence or negligence in his practice.
Gentlemen, Doctor, I know you're head of the Department of Gynecology, Obstetrics. Now that's an area, a field where medical malpractice suits, and I'll use the word proliferate. What's the story there? People tell me that when they see retarded children, when they see cerebral palsy children, that a percentage of these children, and a significant percentage at that, are a result of medical negligence. What is your experience?
That's true. I think that a significant percent, and I'm not going to place a number on that, are reflective of errors in medical judgment that could have been averted, that could have been anticipated and avoided. That's not to say that cerebral palsy and mental retardation secondary to a maloccurrence during labor or during the prenatal course are always reflective of negligence. There are many, many unavoidable biologic events that can injure the child during the process of development and delivery. But certainly a very significant number are related to medical error.
Dick, I know you've gotten million-dollar awards in this very area. Can you comment on it?
Well, obstetrics presents a difficult area that exaggerates the problems of delivering medical care. Many, if not most, medical malpractice cases arise out of two problems. One is what I call the Sunday case, when nobody's around or nobody's around in charge, and the medical care falls on the lowest member of the team, the intern or possibly the first-year resident, just out of medical school. The other problem that brings about more medical malpractice suits than any other is the competition between the desire of a physician like anybody else to work a reasonable number of hours and the need to deliver medical care 24 hours a day, 7 days a week. And the fact that there's no overall structure which can assign people to the night shift. So that when something happens at 2 o'clock in the morning, you frequently find that the problem falls into the hands of an intern who hasn't, moreover, slept in 3 days. It's exaggerated in obstetrics, because if nothing goes wrong, anybody can deliver a baby, including policemen, taxi drivers, and midwives. The tendency to let the intern or the medical student, and there are institutions where I've seen the rules, where the rules specifically provide that the labor of cases is to be followed by the medical student, be in charge of the labor, exaggerates in obstetrics the problems that occur throughout medicine. Many of these problems occur not because our obstetricians aren't appropriately trained, it's because our obstetricians, like anybody else, I won't say they want to work 9 to 5, they want to work 8 to 6. And who's in charge when a baby gets delivered at 3 in the morning is a major problem.
Do you find that to be so?
Absolutely. I don't see the situation, nor have I in any academic institution, where the actual delivery of intrapartum care, the labor care, and the actual delivery is done by a medical student without supervision by a physician, except in the very unusual situation where a patient delivers suddenly and without anticipation and preparation. But what I'm really becoming increasingly aware of is the responsibility of the institution. Interns and residents are worked totally unreasonably. Their hours are inhumane, and that continues to be so. And I think that the only thing that's changing today is the fact that institutions and physicians are becoming aware of the fact, or admitting the fact, that the whole system is unreasonably stressful and produces physicians who are awake at a particular hour unable to deliver quality care.
Let me ask you this, Doctor.
Could I add to that? How on earth would a physician feel if, when he got on the 747 to take his trip, the 747 was being piloted by somebody just out of pilot school who hadn't slept in 3 days?
Oh, I agree with you entirely. Now,
Let me ask a question regarding from a patient's point of view. You're a patient in a hospital. Person comes over to you to render some type of aid and assistance. He's wearing white, or at least a white jacket. He's got a nameplate that says doctor half the time. How do you know if he's an intern, medical student, the chief? I mean, what gives you an idea? What should you say? Should you ask this person before he gives you the shot, before he gives you the intravenous, what status are you? Half the time you're under medication, and what's the responsibilities there?
well, the medical student is generally not and should not be introduced as doctor. They're introduced as Mr., or they don't have a title before their name at all.
I'm
The
sure the
first day the medical student
shaking
meets
of a
his
head, yeah.
resident or her resident, and everybody in medical school who's talked to me in the last 5 years tells me this, the first meeting with your resident, the resident says, now listen, you don't get to touch the patient if you tell him you're a student. You introduce yourself as Dr. So-and-so, and that's true throughout the profession.
Now, that is not true throughout the profession. It's certainly not been true in the academic
Okay, a
institutions.
difference of opinion. Dick, what makes up these $1 million awards? How does a jury determine $1 million for this injury, $100,000 for that injury, and we send you home without any?
Well, as far as the amount of the award is concerned, $1 million awards go to people who have to be carried to the witness chair. Quadriplegics, brain-injured people who have no capacity for living, the most horrible kind of injuries in which life is virtually death in a coffin, but with still functioning heart and lungs, bring seven-figure awards these days in New York State. Six-figure awards of significant proportion result from crippled people. Maimed or crippled in some way that seriously interferes with their capacity to live a normal life. That is the general level of awards that juries are awarding these days.
But I have a question. When a person sits on a jury, the judge doesn't tell them how much to award. The attorneys may request a certain sum, but no one gives them any type of parameters of $1 million for a quadriplegic, $500,000 for a burn victim. How do they themselves, you're on trial every day, the operation of a jury's mind to determine this amount?
All I can say to you is it's a miracle, but it works. The combined good sense, wisdom, and understanding of six people who get together and talk to each other in the jury room has been awesome to me for years.
How long does a person have to bring a medical malpractice suit?
The general rule, which is a terrible thing to say, is 2.5 years. But there are enough exceptions to that one shouldn't pay too much attention to the 2.5 years.
Well, such as what if the injured party is a child?
A child today, right now, and it's going to change in July '85, has until 2.5 years after majority, which is 20.5. Starting in 1985, the 1975 law, which allows a child a maximum of 10 years, will come into effect. So from July '85 on, for those cases, it will be 10 years.
Doctor, when an attorney requests the medical records, or even if a patient requests his own medical records, does a doctor have a chance to review those medical records before either the patient or the attorney requesting them gets it, to review it and fill in anything he's left out? Is that the case? Oh, I don't mean that in any derogatory sense. I mean, if he hasn't filled in anything, he has an opportunity at that time.
Yeah, when the record is requested by an attorney, the bylaws of most institutions provide that record be reviewed first by the medical record librarian, that it be passed to the physician responsible for the patient, and that the record is then released. There's no question about the release, it's the question about...
Have you ever heard of a situation where it actually goes to a risk manager to see if there's any malpractice in that record?
Yes, yes. I have seen those situations, and I've seen the risk manager at that point make a complete copy of the chart and store that, for future reference in order to guard against the possibility of alteration of the record, in order to have ready access to it, because these records have a way to wander and get lost.
Have you found that to be the case as well, Dick?
Records are laundered, records are changed, records are altered with remarkable frequency. One year I tried 6 cases to conclusion, and in 5 of them I had absolutely 100% uncontradictable proof that the record had been changed after the lawsuit got started, either because I had 2 different copies or because in one of them the physician involved had actually gone and ripped up 8 pages in the record and made up 8 new pages, but what he forgot when he stamped the 8 new pages is that particular hospital stamper had a date on it. And there was the date for all to see 2 weeks after I'd sent for the record.
Doctor, when does a patient know he's been the victim of medical negligence? What signs should he look for?
Well, I think that a patient should question bad outcome. When they have been informed about what to anticipate in terms of the results of the surgery and the experience that they're likely to go through post-operatively or after any kind of a treatment, and what they in fact experience in the way of outcome significantly deviates from what they've been told about, I think that they ought to look into it. They ought to ask about it. And when they've asked the doctor and the explanation is reasonable, that's fine. But when it isn't reasonable, then I think that they have reason to be concerned.
Yes.
Can I comment on?
Yes.
Dr. Greenwald mentioned early in the program about frivolous suits. And it is certainly true that there are suits that are brought that, after careful analysis, you see don't bear weight and don't amount to malpractice. Some of that, and not inconsiderable amount of that, and even some legitimate malpractice suits, are brought about because doctors overpromise patients results. In an effort to sell their treatment, they overpromise patients results. I know as a trial lawyer, I have to constantly guard against overpromising my clients' results. But there's a great deal of overpromise involved. Don't worry, it's just routine. It'll be fine in 2 weeks, when the doctor knows the possibilities of complication and not being fine in 2 weeks are substantial.
Dick, we got a letter in from a physician, and he made the following comment or question. He said he sees medical negligence of his colleagues, didn't say himself, and they don't be brought to bear. No suit is commenced, and the case is finished. And then he'll see a matter where there's absolutely not medical negligence, at least in his opinion, and an action is commenced. What has been your experience on that?
Actions are sometimes commenced where they perhaps oughtn't to be commenced. Whether, and I can't really comment on that, but whether or not a patient or a patient's family who has been injured or has an unexpected complication of medical treatment ever goes to a lawyer to inquire about the possibility of a malpractice suit depends almost entirely upon the relationship of the treating physician and the patient. Some of the least competent doctors in town never get sued for malpractice because they know how to maintain good relationships with their patients. Some of the more competent doctors get sued because they're brusque or unsympathetic or what have you.
Dr. Greenwald, let me take you into the OR, into the operating room. And we have a situation, we have a nurse, we have a doctor, we have an anesthesiologist. We have all these doctors around, and let's assume everybody sees the surgeon perform medical negligence, medical malpractice. Do they have any responsibility to the patient to inform that patient what has happened?
They certainly have a responsibility to the patient, to the institution, and to themselves to report that incident to somebody who can deal with it. And I would expect
what does deal with it mean?
Deal with it means to confront the responsible physician, find out the facts of the case, to take whatever action is necessary, which might include, as we were talking about before, removing his privileges for that particular procedure.
I appreciate that, doctor, but does anybody actually go to the patient and say, Mr. Blank, we're sorry, this is what happened in the operating room, and it was because the doctor was too tired or whatever, and your result is because of this. Have you seen that occur?
Yes, I have seen that occur, and it can happen by two routes. I must admit that it's not the most common course of events, but those physicians themselves, whose error resulted in an injury, are the best person, I think, to go to the patient and sit down and talk with them about it. But risk management teams have assumed a lot of that responsibility, or have supplemented the doctor's effort to communicate and educate them as to the cause of the bad outcome. And risk management teams are highly effective in communicating with patients in the language that they understand. And I think that does a lot to allay anger, and I think anger really is the source of many of the suits that are started.
Dick, what does your firm use for a criteria on how to select a case? Everybody's interested. Everybody may have a potential malpractice case, but I know your firm only really takes a small percentage of those inquiries that come to you.
Well,
what's your criteria?
First of all, there has to have been substantial injury. Medical malpractice cases are so expensive to pursue and to prove that that it just doesn't pay, even though the case may have merit for small injury. Secondly, you want to see a result all out of proportion to the treatment. And thirdly, you want to, after analysis, have determined that there were significant medical mistakes made in the treatment after consulting a physician, such as Dr. Grunwald or somebody else. And then you want to see that the departures from good practice that are revealed by the description of the treatment have indeed resulted in the injuries or complications that you're talking about.
Dr. Greenwald, in the few moments we have left, would you like any changes to the current medical malpractice system?
No, I think it's quite effective as is. I haven't heard proposed nor seen, in effect, a change that's had a relevant and favorable effect on the system as it exists.
And Dick, do you have any comments for change?
I think the system works beautifully and has resulted in improvements in medical care.
Dick, if somebody needs a medical malpractice attorney, how do they go about finding a qualified one?
It's as difficult as finding a good doctor.
That's not the answer.
There is nobody who keeps a list.
Can they contact the local bar associations?
I don't think the local New York State trial lawyers would keep a list.
And they're downtown Manhattan, is that
Yes.
correct?
Mm-hmm.
Dick, can all attorneys handle medical malpractice cases?
Absolutely not. It's a very demanding specialty, and unless you've had years of experience, you shouldn't be handling it.
I know you wanted to comment on something Dr. Greenwald said before, and I stopped you. What was that?
I wanted to comment on the idea of doctors exposing to patients what they or their confreres did that might have been wrong. And in 30 years of representing doctors and patients in medical malpractice, I've never seen one instance of it, never once. I have seen just the opposite over and over again. In fact, I've never, when I was defense lawyer, had a doctor ever admit to me in the confidence of the lawyer-client privilege that he might have goofed even a little.
Thank you, Richard. Thank you, Dr. Greenwald. I'm Alan Schnorman, and thank you for watching Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnorman. Mr. Schnorman will be back with you again next week at this same time.